This resolution upholds the institutional power of the House by recommending that the House find Attorney General Merrick Garland in contempt of Congress for failing to comply with the Judiciary Committee's subpoena. It's very simple. Attorney General Garland holds information vital to the committee's legislative oversight and the House's impeachment inquiry. Attorney General Garland has refused to comply with the committee's subpoena, and only belatedly did President Biden invoke an invalid executive privilege assertion over the audio recordings. Special Counsel Robert Hur stated on page 1 of his report, quote, "Our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a private citizen," end quote. Joe Biden not only kept information he wasn't allowed to keep, he also shared it with people who weren't allowed to see it. He shared that information with his ghostwriter. Special Counsel Hur stated on page 231 of his report that President Biden, quote, "had strong motivations to ignore the proper procedures for safeguarding the classified information in his notebooks. He decided months before leaving office to write a book," end quote. A book for which Joe Biden received an $8 million advance. But all this, and Special Counsel Hur declined to prosecute President Biden because Joe Biden is, quote, "a sympathetic, well-meaning, elderly man with a poor memory," end quote. Following the release of Special Counsel Hur's report, both the Judiciary and the Oversight Committees issued subpoenas requiring Attorney General Garland to turn over the transcripts and audio recordings of Special Counsel Hur's interview with President Biden and his ghostwriter, among other information. To date, Attorney General Garland has failed and refused to produce these audio recordings. To determine whether Special Counsel Hur appropriately carried out justice by not prosecuting the president, the recordings are necessary. The transcripts alone are not sufficient evidence of the state of the president's memory. This executive branch has a history of changing transcripts. In late April, during a public speech, President Biden read a teleprompter instruction to pause. He stated, quote, "Imagine what we could do next, 4 more years, pause," end quote. But when the White House put out the transcript, it didn't include the word pause. In that case, and in this case as well, the video and audio recording is the best evidence of the words that President Biden actually spoke. The department's refusal to produce the audio recordings of Special Counsel Hur's interviews with President Biden amounts to a demand that the committee trust the department created and produced interview transcripts are accurate and complete. Following the issuance of the subpoenas, and despite repeated follow-up from the committee, the department continued to withhold the audio recordings of those interviews without providing any constitutional or legal basis to do so. And then hours before the committee was set to meet and consider this contempt resolution, the department notified the committee that President Biden had asserted, at the Attorney General's urging, no less, executive privilege over the audio recordings. This belated assertion of executive privilege fails for numerous reasons. First, President Biden has already waived any potential assertion of executive privilege over the information discussed in his interviews with Special Counsel Hur by releasing the transcripts of those interviews to the media. Similarly, during Watergate, a federal district court held that President Nixon had waived any claim of executive privilege over certain audio recordings of his conversations because he had already published transcripts of those conversations. Second, President Biden's assertion of privilege is not valid because it is more than 2 months late. Any privilege should have been asserted by March 7th, 2024, the subpoena return date. Third, President Biden has not set forth any valid reasons for invoking executive privilege. During these interviews, he was not receiving advice regarding the execution of his presidential responsibilities. Rather, he was sitting for an interview with a special counsel investigating whether he mishandled classified documents while he was a private citizen. Fourth, the law enforcement concerns set forth by the executive branch lack merit and are outweighed by the committee's need for the audio recordings. There is just no reason to believe that individuals will be substantially less likely to cooperate with department investigations of both an interview transcript and audio recordings are produced to Congress, as opposed to just the interview transcript. The department has a legal obligation to turn over the requested materials pursuant to the subpoena. Attorney General Garland's willful refusal to comply with our subpoena constitutes contempt of Congress. Our oversight and impeachment responsibilities are too important to allow Attorney General Garland to willfully and unlawfully disregard our lawful subpoena. With that, I yield back. If they don't exist, I would say that someone has actually destroyed evidence. And that would be a very serious concern if someone actually did something with those audio tapes. I also think it's very important that we clarify some of the testimony that has been provided, which is there is the repeated claim that the transcript and the audio are identical, and that's not true. And in fact, it has been admitted over the last 2 weeks that there are differences between the transcript and the audio that they will not release. And it's one of the reasons why we absolutely have to have that audio, because they are not identical, and anyone who claims to the contrary is being disingenuous.
Agreed. You know, I think we are really splitting hairs here. I mean, it's kind of an amazing thing that we would think about holding the Attorney General of the United States in contempt for not giving the audio version when we have all these people walking around who've never given any testimony at all in answer to subpoenas, and it doesn't seem to trouble, you know, at least your side of the aisle.
No, I get your argument, but I mean, again, if you've already handed over the transcript itself, I would still argue that you've already waived the privilege of then holding on to the audio visual of the transcript. I mean, that's just my understanding. I understand you're saying we're splitting hairs here, but Ms. Hageman?
Yes, a couple of things. To conflate the outcome of the two cases between Hunter Biden and President Trump is an absolute absurdity. It's also an absurdity to claim that the outcome in one case with Hunter Biden being convicted today is reflective of the viability or legality of what happened in New York is also absolutely absurd. So I wanted to set that, I wanted to point that out.
Can you explain
to say
why?
That these two, I think that the facts are very clear in the record in terms of the differences between the two cases. And
To the juries, it was very clear.
And the legal basis for
Yeah,
it.
and in both cases,
asking about the privilege and waiver. And it seems as though my colleagues on the other side believe that a privilege or a waiver is based upon a word-by-word basis, and the extent to which they may have waived any kind of a claim of privilege for the words that were included in the transcript, they would still be able to claim a privilege for the words that were left out, and that's what we're trying to get to with the audio, is also a legal absurdity. That is not the way that privilege or waiver either one work. What it is when you waive the subject matter, then you waive the subject matter. You have waived your ability to claim a privilege for those issues. You're not able to use privilege as both a sword and a shield and say, well, I'm going to release these 4 words, but I'm not going to release these 16 words. These 16 words are privileged, but these 4 words I will give to you, and there's a waiver. What a court would rule in that regard is, to the extent the 16 words relate to the 4 words, it's a waiver of the entire thing, because they're not going to allow you to use privilege as both a sword and a shield, which is what my colleagues on the other side seem to imply. I'd like to read 3 quotes from the Her report that put the issue that you have raised, Mr. Reschenthaler, front and center here about Mr. Biden's cognitive abilities and why the audio is so critically important. Quote, Mr. Biden's memory was significantly limited both during his recorded interviews with the ghostwriter in 2017 and in his interview with our office in 2023. That's on page 5, I believe. Quote, we have also considered that at trial, Mr. Biden would likely present himself to a jury, as he did during our interview with him, as a sympathetic, well-meaning elderly man with a poor memory. That is on page 6. Similar quote on page 219 of the report. And finally, Mr. Biden's memory also appeared to have significant limitations, both at the time he spoke to Zwanitzer in 2017, as evidenced by their recorded conversations, and today as evidenced by his recorded interview with our office. That's at page 207. I'd like to bring this back to actually what the purpose of this hearing is, which is our oversight responsibilities, both as the Judiciary Committee as well as the Oversight Committee. That's what this is all about. And I would say it's very obvious that the point of the other side is to deflect attention. They want to deflect attention from the fact that Joe Biden had unlawfully kept classified materials and shared them with his ghostwriter, for example. They want to deflect attention from the fact that clearly the audio and the written transcript are different, and that those differences might be incredibly significant in terms of our oversight responsibilities. It's clear under the Constitution, it's clear under the case law that judiciary and oversight have the authority to obtain information such as this in carrying out our responsibilities as the legislative branch. That is really the only issue that is before this committee today. All this other nonsense, all this other noise, all these other words that are being thrown against the wall are entirely irrelevant as to whether we're entitled to this information, and if so, by withholding it, should Merrick Garland be held in contempt of Congress? And the fact is that he should, because there is no executive privilege. Even regardless of the transcript, there is no executive privilege for the information we're seeking, number one. And number two, if there was, it has been waived, and we're entitled to receive the information, the audio that we have requested. I'm happy to have that debate
Please.
with you any day of the week.
Please.
But I just don't think that that's relevant to what we're discussing.
Well, you brought it up, so
I mean,
why
we
don't
can,
you
we
explain
can
it?
start with
You
the
said it was
judge, the
absurd.
judge-
Wait, hold on, Ms. Hageman.
all
Ms.
right,
Hageman.
we can start with the judge that was handpicked rather than randomly chosen, which is typical in most of your court cases. You can talk about the fact that you talked about unanimity of verdict. We don't even know what the verdict was at this point in terms of what he was allegedly convicted of unanimously. We can talk about the fact that almost every single ruling that was made by Judge Marchand in New York was against the defense, despite the fact that when you're dealing with a criminal case, there's either typically much more of a balance, or in fact to ensure that the prosecution actually meets its burden of proving beyond a reasonable doubt, most of the rulings would be in favor of the criminal defendant, not in favor of the prosecution. It's in the fact that the expert witness, who is the former head of the Federal Election Commission, was excluded from testifying as an expert witness in the case in New York, despite the fact that he has been qualified as an expert witness to testify on these matters throughout the entire United States. It is the fact that there were other witnesses that were excluded. There was substantial evidence, prejudicial evidence, that was admitted during the course of the trial. And then when you look at what happened with Hunter Biden, the prosecution was very precise, very specific about the nature of the statute that was at issue and how he violated it. And then they brought in the evidence from the family members, the ex-wife, the girlfriend, Beau's widow, the young girlfriend, all of the testimony, him reading the book, all of the testimony. The evidence was overwhelming that Hunter Biden had violated the specific statute at issue. So there's dramatic differences in terms of how the New York case was handled versus how the case against Hunter Biden was handled. If you'd like to spend another 3 or 4 hours, we can go outside and I can give you additional evidence to that effect. That is absolutely untrue. Neither Jim Jordan nor anybody on the Judiciary Committee made any changes to Nita Jankowicz's interview transcript. That's absolutely a false statement. There's one other point that I think needs to be clarified, which is that Special Counsel Robert Hur stated on page 1 of his report, our investigation uncovered evidence that President Biden willfully retained and disclosed classified materials after his vice presidency when he was a vice president. The reason that he recommended against prosecuting President Biden was not a gratuitous statement. It was the reason as to why he refused to recommend prosecution, and it was that because Joe Biden is a, quote, sympathetic, well-meaning elderly man with a poor memory, Mr. Hur was concerned that a jury would not be willing to convict. Anyone who wants to see what Mr. Hur actually found and his explanation of what he did, you can go and you can watch the hearing before the Judiciary Committee. But one thing is very clear, and I will go back to it again. The folks on the other side of the aisle keep wanting to say the transcript and the audio are identical. There is no reason why, if you have the transcript, you're entitled to the audio. As a long-practicing attorney, they are not the same thing. The audio is the best evidence of what he said, how he said it, the time that it took for him to say it, and in what ways they may have altered that transcript. The moment that they released the transcript and said, this is the interview, they waived their ability to claim any kind of a privilege, and they don't have a legally valid privilege in addition to that. And it's for that reason that we believe that Merrick Garland needs to be held in contempt of Congress.